You're also welcome to my live show today. Today I'll give you very important good news for many. Uh, their case law come. Those who lost their case in appeal stage in the upper tribunal from March to till this period till today, the High Court gave a decision which declared the pandemic rules for immigration appeal. Basically, they declare unlawful for those who lost their appeal in the court of in the upper tribunal. Now you have a good news. I also give an important court decision today from the European Court of Human Rights about deporting gay asylum seeker is violate Article 3 of European Convention on Human Rights. So this is also good news for those who seek asylum in the UK on the basis of their sexual background. I also important update for student now. International student come to the UK to learn English for a course to 6 to 11 months, and the Home Office add a new appendix which is for short-term study student visa English language for those who want to learn English. Also, I'll give a few update about immigration help, immigration rules due to the coronavirus lockdown and pandemic, especially for fee waiver and recourse to public funds. Those who are struggling to maintain themselves to pay rent, or they cannot buy food because of they don't have access to public fund. And finally, the help available for asylum seekers. Stay with me, and I'll come after a short break. So first, I'll start from pandemic rules for immigration appeals declared unlawful. So this is a very good news for those applicants who lost their appeal at the upper tribunal during the pandemic times. The High Court has declared that the arrangement for dealing with upper tribunal immigration appeals during the coronavirus pandemic are unlawful. The reason is the upper tribunal introduced paper-based hearing, and many applications refused compared to the oral hearing. And Mr. Justice Fordham held that the president of the upper tribunal guidance leans too heavily in favor of deciding the cases on the paper rather than having a hearing, a situation that is inconsistent with the basic common law requirement. The tribunal must now write to everyone who lost a paper appeal since 23rd of March 2020, telling them to seek legal advice. The case is Joint Council for the Welfare of Immigrant versus President of the Upper Tribunal, Immigration and Asylum Chamber 2020, case number EWHC 3120. So this is the I think this is will be great news, and a lot of people lost their appeal in the upper tribunal during the pandemic, during the coronavirus pandemic. And even I myself observed a few of my clients who lost their appeal. And my observation, if it would be if it could be a oral hearing, that my client would win the case. Now, as if you are aware about it, or if any of your friends or family who lost their appeal in the court in the upper tribunal during the pandemic time, you can ask them to contact to the upper tribunal, or anyway, upper tribunal will write to all the applicant, all the appellant who lost their appeal to the upper tribunal during this pandemic time. So probably the upper tribunal will invite you to an oral hearing. So this will be a second chance for you to win your case. The second important case, because I'll not speak about the point-based system today, or I'll not give the update about the work permit. A lot of people are talking about in Facebook, like YouTube, in TV, in different platforms. Today, I'll give you the case law. Basically, case law means the cases which is decided by the High Court, Court of Appeal and the European Court of Justice or a Human Rights Court in Strasbourg. So these are the decisions which appeal court or high court or the court of or the European Court of Human Rights decide, and then the decision is most of the cases is binding, or the Home Office introduce or make decision according to line with the outcome or direction or decision of the court. So deportation gay asylum seeker. This is the first time, and from my experience and so far I know, this is the first decision come from the European Court of Human Rights in Strasbourg that is deporting gay asylum seeker violate Article 3 of European Convention on Human Rights. In England, a lot of people seek asylum on the ground of their sexual orientation or sexual background, especially from Middle East, from Asia, and from Africa. And the court, or the European Court of Human Rights, has said that they unanimously held that the deportation of asylum seeker to a country where the risk prosecution for their sexual orientation would violate the Article 3 prohibition on torture and inhuman or degrading treatment under European Convention on Human Rights. And the case name is BNC versus Switzerland, application number 43987/16 and 889/19. So this case is very important case, and this is the decision of the highest court of the Human Rights Court, and now the UK court will consider this these guidelines. And what the court importantly said in this case is that the important point to take away from the case is that the state will be in breach of Article 3 if it does not conduct a proper investigation of both state and not state risks. What it said that when someone seeks asylum in a country, for example, if someone asylum in UK, the UK will have a obligation to investigate whether, if this person deported to his home country, whether he will face state prosecution and non-state prosecution. This is the big trouble in our society, especially from if I look at Asian country, same African country, in Middle East, because for example, if a gay person deported to in Africa or in Iran or in Bangladesh, okay, state will not do anything. Maybe state will not take him in prison. However, non-state risk, for example, the society, the community, that his family will prosecute him. A lot of extremist group will prosecute him. Now, especially from my experience in Africa, the society community prosecute gay peoples. In Arab, the community, the extremist group prosecute, the government prosecute them. In Bangladesh, in Asian countries, same situation. Pakistan, same situation. Now, if someone seek asylum on the basis of his sexual orientation, now UK will have an obligation to investigate whether he will be prosecuted by non-state actor, state, society, community, family. And this is the very important. And if he faces that risk in his home country, the state will not deport him. If they decide to deport these types of asylum seeker, the state will violate Article 3 of Human Rights. That's what. So as soon as you can establish the fact that you are a gay, and for example, if you will face definitely, from my experience and the society we came from in Bangladesh or Pakistan, India, Africa as well, the society doesn't accept behavior the gay people. So this is a solid ground and guidelines given by this by the European Court of Human Rights today, and the decision was a unanimous decision. So those who already seek asylum as a gay, or those who your asylum application is pending and you have an issue and you seek this asylum claim on the basis of your sexual orientation, have a look this case. The court discuss and explain and give a lot of resources, and it is very helpful. So when you seek asylum, obviously, or if you do an appeal to the court of appeal or high court or the upper tribunal, you address all the point what the court discussed. And this is the first time case, because I deal with cases, asylum cases, and actually it is very difficult to find a case for from the Strasbourg European Court of Human Rights on gay asylum seekers. So this is the first time case, and the court explained that the state has a duty, state has an obligation to investigate proper conduct, to that proper investigation of both state and non-state risks on return for lesbian, gay, bisexual, transgender, and intersex people. So the thing is not only say about gay, although this case was about a gay asylum seeker, because this person was gay and he seek asylum. The state decided to deport him, and then he anyway. So this is this a bit long history, but as because of just only the code did not deal with the code didn't code doesn't deal with only the gay issue. The code bring lesbian issue, code bring the give guidelines about the bisexual, transgender, and intersex LGBT whole community. So this is I think this is a historical decision. So anyone who is in this case is relevant, have a look the guidelines, and I think this case is very helpful for those who want to seek asylum in the UK. Now, student visa. This is also changes. First changes the point-based system, which is supposed to start from 1st of January, which is bring forward from 1st of December, and there is a new appendix added to the immigration rules, which is English, which is short-term student visa, English language common. So a new short-term study route is being introduced for students who wish to come to the UK to study English language for courses between 6 to 11 months. Replacing the current rule, because right now the immigration rules, what is short-term student visitor visa, which is replaced a new short-term study visa for English language. So those who want to learn English, a course between 6 to 11 months, you can come to the UK. The requirement is the study must be at an accredited institution. A student who wish to come to the UK to study for 6 months or less, then you need to come as a visitor visa. But if you want to come to the UK to study or to learn English for a course which is last for 6 to 11 months, you can come on short-term student visa. And then the Home Office introduced a new appendix. The appendix is called short-term student visa. Appendix short-term student English language. So I think if any student now, international student who doesn't speak English, you don't have English certificate B1 or B2, most probably this type of student comes to the UK to learn English, so courses which is last for 6 to 11 months. But obviously there are one more question and one more but, which is you have to be proof that you are a genuine student. So you need to pass a genuine student test, which will be subject to discussion of the anti-clearance officer. When you make the application, the anti-clearance officer will interview you, and then he has to be satisfied that yes, you are coming to learn English to the UK. But if your purpose or if your intention is to come to the UK and then you will run somewhere, then obviously if the anti-clearance officer is not satisfied that you are not a genuine student, your purpose is different, not study or to learn English, then you will not get visa. You cannot appeal against the decision of anti-clearance officer, but what the judicial remedy is, you can make, you can challenge the anti-clearance officer decision by way of judicial review. So, I think this is a good news anyway, because now you can come to the UK to learn English. Point-based system again, student visa route bring forward to 1st of December. It is supposed to start from 1st of January. So this is all about update. I spoke about two important case, those who lost their appeal in the upper tribunal during the pandemic time. Now the High Court High Court gave a decision that the pandemic rules for immigration appeal declared unlawful. That means those who lost their appeal to the upper tribunal on the basis of a paper hearing, now you should seek legal advice. Now probably you will be invited for another oral hearing, so you'll get one more chance in the same upper tribunal. Because in the case Joint Council for Welfare of Immigrant versus President of the Upper Tribunal, this case decided the High Court, and the High Court has declared that the arrangement for dealing with Upper Tribunal immigration appeal during the coronavirus pandemic are unlawful. Also, I spoke about the case law that gay asylum seeker is a good news that the deportation of gay asylum seeker is breached the Article 3 of European Convention on Human Rights. More importantly, the comment of the judge in this case, the judge said that basically that the state will be in breach of Article 3 if it does not conduct a proper investigation of both state and non-state risks on return for lesbian, gay, bisexual, transgender, and intersex LGBT community and LGBT people. So this is a good case for those who wish to seek asylum on the basis of your sexual orientation. So let's move to immigration rules, relaxation of immigration rules for the coronavirus pandemic. I'll speak. This is although we are nearly end of the second lockdown, but still this route is open. So I'll speak about fee waiver and recourse to public fund and help for asylum seeker. So fee waiver and recourse to public fund is basically for those people who cannot pay their bills, who cannot pay their rent, who can find difficulty to buy their foods for their family, and unfortunately you are struggling. You can make an application to the Home Office to give you access to public funds, because your BRP right now not allow you to get public fund, universal credit, housing benefit, tax credit, child benefit. Even your child is British citizen, but you cannot claim child benefit. Very unfortunate, because child benefit is also a public funds. So now if your situation is like that, Home Office, trust me, Home Office is very flexible right now. Every single application whatever I made for fee waiver application and a request to public fund, alhamdulillah, successful. So you take the opportunity, take the advantage from the Home Office. So if you want to make an application right now, the NHS fee increase, which is £1,560. Subhanallah, is a huge amount of money. It is very difficult. If you make an application now for one person, you need to spend nearly, including the professional fee, £3,000. Now think a family which have 2, 3, 4 people, 10, 20, 10, 15,000 pound will come NHS fee and the Home Office fee. So it is very difficult for them to make an application. So what you can do? What are the remedy? What are the Home Office guidelines? Is there any help available? Because you cannot pay the Home Office fee, you cannot pay the NHS fee. Yes, there is a help available. You can make an application for fee waiver. You can make an application for exemption from NHS fee. These rules is available, but many people doesn't know. Many professional doesn't advise their client to make an application for fee waiver. So my suggestion is, my advice is, if you find difficulty to pay the Home Office fee or NHS fee, make an application for fee waiver, which is a fee waiver application. If you have visa, however, your BRP doesn't allow you to recourse to public fund, then you can make an application to recourse to public fund. But both application, whether fee waiver or recourse to public fund, to access to get benefit, the requirement is same. What you have to establish, that the legal term, the codes, the immigration rules said that you have to be a destitute. Now, who is a destitute? Destitutes are those people who cannot pay. There is 3 groups who cannot pay their rent or buy their foods. Second group, who can buy their food or pay rent, but they cannot pay the Home Office fee. Now, third group, those who can buy food, pay rent, and may able to pay the home office fee, but if they pay the home office fee, they will be destitute, means that they will have not left enough money to pay rent next month or to buy food for their family, for their children. If your situation like that, and you can provide evidence to the home office, you need to provide how much you earn per month and how much you spend per month, how much rent you pay. You need to provide your tenancy agreement, you need to provide your utility bills, you need to provide your expenditure for 1 month calculation, 6 month calculation. You need to keep all the receipt, you need to pay your pay slip, you need to provide your bank statement. All this evidence you need to submit to the home office. I will not tell that fee waiver application or recourse to public fund application is just straightforward. It's not a straightforward application. This application is bit technical than the normal leave to remain application. However, if you can provide all the supporting evidence, granted you will get fee waiver application, granted you will get recourse to public fund. So during the pandemic time, home office almost 99% application they grant as soon as you provide all the supporting evidence, provide all the required document. Home office accept the application and grant access to public funds, means recourse to public, and also grant fee waiver application. You don't need to pay any NHS fee, you don't need to pay any home office fee as soon as you set up yourself in the destitute. Now, why the home office become bit flexible. In March or April time, there is a case law came from the Court of Appeal, and in this case law, this is about who eligibility of fee waiver or recourse to public fund application, and the court said that the eligibility requirement for fee waiver or recourse to public fund shouldn't be destitute. The eligibility or criteria should be who can afford and who cannot afford. That the court published a guidelines and gave that decision, and following the decision, home office is bit flexible to give fee waiver, to give NHS fee exemption and fee waiver, and also recourse to public fund. So take the advantage. If you need any help, make the application. If you need any help from I think if you're not sure whether you are eligible, speak to a solicitor, speak to a legal advisor, expert experience who have wide knowledge about these guidelines and these immigration rules. Next, help for asylum seeker. During the pandemic times, UK Home Office Chancellor Boris Johnson was very flexible sympathizer to their citizen, residents, worker, company, employer, employee, for everyone. They pay their 80% wages for the employee. They pay the help out it out. They pay for grant 50,000 loan interest free. They pay grant from local authority 10, 20,000, 25,000, a lot of money. Does the government or the Home Office also show their sympathy to the asylum seeker? Yes, they show some form of sympathy or during the first lockdown period, and still they are now there are still help available. Now, asylum seeker, what types of help they can get from the Home Office right now due to the lockdown? Now, asylum seeker, if you are asylum seeker, you can get financial help, you can get accommodation help from the local authority charity. The eligibility requirement to get this help as an asylum seeker is you can apply for asylum support if you are homeless or do not have enough money to buy food. If your situation is like this, you need to make an application form. If you go to the Home Office and Google form ASF1, this form you need to download it, fill up it, and send to asylum support casework team, post office box number 471, Dover City 169FN. Form name is form A, capital S, capital F1. This form you need to fill up and send it to the Home Office. The address, and in the form there is an address and how much and what help you will get. Well, you will get £37 or £35, depend on your situation. Every week they will not pay you money directly to your bank account because they presume you don't have a bank account. But what they will do, they will issue you a debit card which is called Aspen card, and on this card they will every week they will loaded 37 pounds 75 pence. So this is the money you will get. If you have a family, for each person you will get same amount. If a pregnant mother, she will get £3 for baby, £5 for child age £3. Although it's a small amount for laughing, but as if you are pregnant, you can if your mom is pregnant, if a woman is pregnant, she can apply for maternity £300 one of payment, and you can apply of one of another 250 maternity payment as well. When his baby is 6 weeks, or when the baby is due to 8 weeks. So this is what help available. You will get free prescription for medicine, free dental care for your health, free eyesight test, helping for your glasses. So this is the help available for asylum seeker. Also, if you don't have enough place to live, you can apply another form also, and you ask the home office. Then the home office will arrange you accommodation or a hotel from the local authority, or they will arrange your alternative accommodation. This is the help available for asylum seeker, but I'm not sure when they will stop, whether after the second lockdown in December or in March, because furlough scheme extended to March, or maybe we are hoping another lockdown will come after Christmas. So maybe this help, or this scheme will be extended again. Anyway, this is all about today. If you are benefited by this short video, you can share it. Today I speak about two important cases. One is the upper tribunal, those who lost their appeal in the upper tribunal. You can now the High Court give a decision from a case that the immigration rules during the pandemic time for appeal for upper tribunal is unlawful. So you probably will invite it for another oral hearing, or you can contact to the court, and this will be a second chance for you. There is a case law, important case law, come from a European Court of Human Rights in Strasbourg, that is about the gay asylum seeker. That is, the deportation of gay asylum seeker is breach Article 3 of European Convention on Human Rights. Also, student visa, the international student come to the UK for a short-term study course, 6 to 11 months for to learn English. So those who want to learn English, they can come to the UK now. So this is the three important update for today, and I gave you some brief discussion about fee waiver application and recourse to public fund and help available for asylum seeker. Everyone be safe. Have a nice weekend. I'll see you tomorrow again, hopefully. Until that, look after yourself.